was arrested on the warrants. He paid a large payment to get out. He would like to request the court to apply half of that bond. He runs a car. I'm trying to talk fast and it's not working. A mechanic.
I own a shop now, and my rent is $1,200. I have to work. I have to work to pay it. I need to pay my rent.
Okay.
And then
So how much do you want to pay a month? Case versus Christopher Mayberry.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Mayberry. Mr. Mayberry, state your name for the record when you approach the podium.
Mayberry. Sorry. My sugars are low. Sorry.
Pardon?
My sugars are low.
Is that okay?
Yeah, they're plummeting. Like,
We'll get you out of here.
We're here for show cause, Your Honor. A couple things. Mr. Mayberry has made two $500 payments this year. One was bond was applied, and I think the other one he made a payment. Maybe it was $450. I believe in March.
I'm good right now. It's like I didn't eat enough for this. Like, I'm down to 90 right now. I think
Okay.
I should be good.
I'm gonna talk quick. So he was arrested on the warrants. He paid a large payment to get out. He would like to request the court to apply half of that bond. He runs a car. I'm trying to talk fast and it's not working. A mechanic.
I own a shop now, and my rent is $1,200. I just need to pay $1,200. Like, I can pay, like, just this is the beginning of the month. I just need to get this out of the way. I have work lined up. I have cars at the garage.
Monthly payments.
I screwed that up. I also have glaucoma.
I know.
So when the last time I saw you, I now have glaucoma. I'm losing sight in this. Over here is blurry, and I've been going to doctor's appointments and working still. And unfortunately, this is my stronger vision. I'm going through a lot.
Mhm.
I have to work. I have to work to pay it. I need to pay my rent.
Okay.
And then
So how much do you want to pay a month?
I'll say $100 a month, but it's gonna be more than
That's
that.
fine.
It's gonna be more than that. I want this done.
We'll say pay $100 per month beginning in August.
Okay.
All right. 2026. All right. Thank you. Go take care of yourself.
Okay.
Regarding his bond.
I don't, hold on a second.
Sorry.
I don't see a current bond.
I think it was 25,000, 10%.
Sorry, this wasn't at, so we don't have any bond information yet.
All right. So he paid 2,500.
Yeah, it was set at 10%, but he was just released yesterday. I don't have access to that information yet.
How much did you pay?
I paid 2,500.
Okay.
I just need.
So hang on. The rent's 12. Right.
He runs 12.
Yes.
So what I'm going to do is apply $1,200 bond posted, and we'll return the balance.
Thank you, Your Honor.
Okay. Thank you.
Okay.
You're bringing that one first. Well,
Will be my order now.
Walter, Mike.
Yeah.
Partners.
Yes, sir.
Court recalls case, People versus Nicole Henderson.
Morning again, Your Honor. Raymond Cook for the people.
Good morning, Nicole Shawty. I'm still present, and Miss Henderson
is walking up to the podium now.
State your name, ma'am.
Nicole Henderson.
All right. We have finally received an order. I've signed that order. Mr. Statman has indicated, Ms. Blair, if I'm correct, can see you tomorrow at 10. The next question I had for Mr. Statman, which I think we got cleared up, is that he can then have a report by 1 o'clock, noon, 1 o'clock tomorrow. Okay. And then what I'll do is I'll adjourn this hearing to July 9th tomorrow at 3 p.m.
I can do that.
All right. And we'll see what we can do.
Thank you.
You're welcome, ma'am.
One last thing,
Yes.
separate from that, I spoke with defense counsel. I believe we sorted out the discovery issue. We never received the original substitution. I've forwarded that now to our team. So that discovery should be coming within the next day, I hope.
So you didn't receive the discovery, but now have it.
So we didn't receive the substitution of attorney or the appearance. We got that now. I think it was the same issue with the emails that were sent to the court and to us regarding the motion where we just never received it. We have that now. It's been sent over and forwarded. So
All right. You're going to buy this.
I have an
Fine. Thank you.
alternate email address, Your Honor. So I have an alternate email address that is working with your staff. So I'll just make sure everybody has.
And then you said 300 a month.
Yes.
All right.
Also,
So
Your
I'll
Honor,
indicate-
I'm sorry.
yes, sir. Go ahead.
I have a I need to be reminded on how, like, where to go and pay online, or do I come into
All right. Are
the,
you going to pay by, are you going to pay by card, or are you going to pay, you want to bring cash in?
I can pay by card.
All right. You're on a phone. So if you slide across, you'll come across a QR code.
Oh,
You're muted.
I'm sorry. Yeah, I see it. Scan to pay fines and
Oh.
costs.
Right. So you just scan that in and that'll take you right to the site to pay it off.
Okay, that sounds good.
Okay. Okay.
Thank you.
So I'll indicate, you're welcome. To pay $300 today and then $300 per month
Correct.
until it's paid in full. All right, sir?
Thank you.
Thank you.
You have a great day.
5.8. Court calls the case, People versus Diamond Edmonds.
This is how defendant Nicholas Bukovich on behalf of Ms. Edmonds.
Are these no show cause? Miss Edmonds, can you state your name?
Diamond Edmonds.
All right.
I was unable to speak to my client before today. I did send her an email with the fine and costs owed, so I would have to ask her what payment she could make.
Miss Edmonds? You
Yes.
owe about, I think I have a total amount of 1,020.
Yes, between two cases, yes.
And how are you gonna get this paid?
Can I do a payment plan?
I don't have a problem with that, but okay, tell me what you can do. You have two cases, one you owe $520, the other you owe $500.
I could do $50 every week.
When are you gonna start that?
When I go back to work in 2 weeks, got to a car accident, so
All right, then I'll just put $50 per week starting, I'll just start at August 7th. How's that?
okay.
And that we'll start that on case 1828. And then on the other case, it'll be $50 per week. When case 1131828 is paid. So what I'm doing is you're going to pay on the one case first. Once you get that paid off, which should happen in about 10 weeks, then you'll start paying on the other case.
Okay.
Okay? All right. Thank you.
Thank you, Your Honor.
Thank you.
Okay. Court calls the case before versus Lamar Hampton.
Good morning, Assistant Public Defender Lauren Attorney on behalf of Mr. Hinton. Check. Your Honor, we attempted to call Mr. Hampton, we sent an email, we don't have anything.
Bench warrant will issue for defendant's failure to appear bond to set an amount of $10,000. If a 10% privilege, that warrant will issue immediately. Court calls the case People versus Jacob Hodge.
Good morning.
Jacob Hodge.
On behalf of Mr. Hodge. Maybe his name, Your Honor, I would ask that Mr. Hodge let the court know if he can make his payments on this. Looks like he owes us $713.
Exactly 713. Well, no, and 78 cents. Mr. Hodge, how can you get this paid?
I'm not currently employed at the moment, but I'm actively looking. I would like for you to adjourn it out 2 weeks at most until I get a job.
Right,
then I can start paying as soon as possible.
I'll adjourn the matter to August 12th, 2026, 9 a.m.
All right, thank you.
All right, thank you. Court calls the case People versus Michael Johnson.
Morning, Assistant Public Defender Lauren Attorney on behalf of Mr. Johnson, Your Honor, we did call and email Mr. Johnson, he's not.
Easier.
Mr. Johnson,
Can you state your name, please, sir?
Michael Johnson.
All right.
well, we didn't speak with Mr. Johnson, so I would ask him as well to report if and when he can make payments.
You have $1,680 that's due.
Correct. I just made a $50 payment today, and I would like to request a payment plan of $50 a month.
Okay. I'll do it. How does he get? Oh, this possession church. All right. Defendant to pay $50 per month. Beginning August 14th, I'm sorry, 2026. What's today? All right, sir. Thank you.
Thank you.
Court calls. Oh, Brennan Barrett. Will toss.
Yeah.
The one that, yes. The one that answered. Oh,
Okay, I got you.
so that's why I'm having. One of the many reasons I'm having issues. Court does call the case, People versus Kevin Davis.
Your Honor. Your Honor, Raymond Cook is the-
Good morning, Your Honor. James Fifelski on behalf of Mr. Davis, who is approaching. You state your name, please.
Kevin Ryan Davis.
Thank you.
Your Honor, discovery is complete and we are asking the court to set this for preliminary examination.
People have their witnesses available the 16th. Preliminary examination will be set June 16th, 2026, 9 a.m. before judge for me. Bond will continue.
Thank you very much, Your Honor.
Court calls the cases of the People versus Jamari Bagwell.
Brandon Dover for the people, Your Honor.
Michael Gaddy, assistant public. This is back line. February 26 FP.
And Kyle Burdell on behalf of Mr. Bagwell in matter ending in 0623. Good morning.
Good morning, sir.
And Mr. Bagwell, please say your name for the record.
John Muir Bagwell.
Your Honor,
So that. Okay,
he's acting in absolute wrong order.
All that.
Bagwell.
like blocked her out. It's like myself in the back. I'm going, what? Where's she coming from? All right.
Well, Ms. Constantino's here, Judge, because I realize I have a conflict on this matter, and I must withdraw. When the court sees fit, I would like to make a bond argument on behalf of Mr. Bagwell. But also,
Drawing, but you want to make the bond argument. Is that what it is?
what?
Okay, sorry.
The court will hear it. Thank you, Judge. Mr. Bagwell is 35 years old. He has
Okay, so go ahead.
his his children are ages 13, 8, and 3. The 3-year-old is the primary caretaker of his child. The 7-year-old, she's currently in the custody of his brother. It's my understanding that that's not an ideal situation for anybody. He does have a sister. His brother obviously helps him quite a bit. His sister helps him. The mother of his child, he's got friends who are very supportive. We would be okay with the GPS tether. Preferably it would be PR bond, but we did have a discussion with Mr. Bagwell that a GPS tether would be acceptable.
And the public defender would concur with that argument, Jim.
All right. So first of all, is there a response from the people?
Yes, Your Honor. People will ultimately, for its discussion, I would just remind Rush for the defendant does have several of these.
Does he have a PR on his other cases?
I think of the other case that I have him for. I know he's on a bond violation, I believe. Do you have PRs on your other cases? I believe so, Judge. It's my understanding, yes.
Sure. So, I mean, I guess my question, maybe I'll put it simply, if I were to accede to your request, then would he get out, or we don't know?
You know, let me check. Let me double check. I believe he would get out, Your Honor. I know he has.
Why don't I do this? What are we doing with the case?
We're just giving an adjournment today, Your Honor. Perhaps a nominal cash bond today, so he gets credit if he doesn't get out.
Okay.
Christina Costantino on behalf of Mr. Bagwell, Your Honor. We are asking for an adjournment of the PCC. Given what the court's just heard, I'll be taking over the case. I do need to get discovery in this matter, which I haven't been able to get until now.
Gotcha. So what I'm going to do is this. I will adjourn his cases to the 18th.
All right.
I will certainly entertain I will at this point deny without prejudice your request for release. Let's figure out if he would be released and then under what circumstances we could then have him released. I would, you don't want to wait to that date. If a motion comes through, I'll try to hear it on the 11th, a week before. But let's get all the information to me.
First, the existing, it says there's a whole lot of Van Buren. That's the only thing I see. It doesn't say that they're going to pick them up though. It's a, looks like a misdemeanor shop out of Van Buren town.
Okay, but there's another, okay, thank you. But my understanding, counsel, is you have him on some other case?
I have him on, he's on probation, Your Honor. It's a probation. So he's not, I don't believe that's keeping him.
Are they holding him on that?
It was a violation for a different, it was a previous violation, Your Honor, for a different issue. And that is, he was released on that case, yes.
Okay. I'm going to do it the way I was doing. I'll do it the 18th. Sconsino, you can look into that, file the motion, give me everything, and then I can make an informed decision.
Understood.
All right. So at this time, the motions.
Thank you, Judge.
Judge, and just given that, would the court mind scheduling this on the 11th? I know it's only a week away, just so that way we could come back and address that since he is in custody.
All of you are out of control today. Fine. Change it to the 11th.
Thank you, Judge.
Thank you, Judge. Thank
you. May I approach with a green sheet, Judge?
Really?
Yeah.
It's the coffee.
Mr. Bagwell, I'll see you either.
Okay, thank you. Yes, ma'am.
Yes.
Yes. Court calls the case, People versus Daniel Polgar.
Morning, Your Honor. Thank you to the people. Kyle Burnell on behalf of Mr. Polgar, who is approaching the podium. Mr. Polgar, once you get up here, please state your name for the record.
Daniel Polgar.
Thank you.
And Your Honor, the court should be in receipt of a green sheet. I believe the people have are working on some video on their end.
That's correct. We're waiting for CAC's interviews on this matter.
Okay.
Second of those will be taking place on the 15th of this month. I would ask for something towards the end.
Okay, I can do the 25th of this month or the 2nd of next month. Which would you?
I'm here already on the 25th.
Are you?
Yes, Judge.
Oh, joy. No.
Oh, it's consolidated. That way you don't have to sell it twice. I mean, every week you can put me on the 2nd.
No, that's fine. I don't mind seeing you. You'll be in a much better mood now that you're married.
It's funny how that works, Judge.
What?
Funny how that works.
Really is.
Yes.
You just don't know. All right. We'll adjourn this to June 25th, 2026 at 9 a.m.
Thank you, Judge.
Thank you.
Yeah, thank you.
Time will continue. Court calls the case of the People versus Cidalia Benton.
James Feitfelski on behalf of Ms. Benton. Counsel approach, please.
Yes, you may.
Thank you.
You got it.
I got it.
Portia, please to assist.
Thank you, Your Honor.
Conference in this case, and I'm not even at this point going to say what that's about. It's about the defendant's location. I'll just put it that way. And I will adjourn the probable cause conference out 1 week to the 11th, June 11th, 2026, 9 a.m. Bond will, at this time, will continue.
Thank you, Your Honor.
Okay, thank you. Come back. There we go. Court does call the cases of the People versus Christopher Madison.
Brandon, it over to the people, Your Honor.
Ready, Judge. Portia Feaster, Assistant Public Defender, on behalf of Mr. Madison, who could be in custody. Your Honor.
State your- Christopher,
Yes,
state your
sir.
name.
Christopher Jerome Madison.
Thank you, sir.
Thank you, Judge. I did have to speak to Mr. Madison a few times over the last few days. His primary concern was he wanted me to address his bond. At this point, we're not ready to proceed, so we'd be asking for an adjournment and for me to address his bond, Your Honor.
And do what?
And he wants me to address his bond.
All right. I'll adjourn it to June 18th, 9 a.m. as to bond.
Thank you, Judge. Mr. Madison did indicate that he missed a court date, I believe, and that's why why he was put into custody. He'd be asking the court to consider changing that and allowing him back out of custody. He says that he could afford to pay the bond, but he doesn't have anyone who can go get his money and bring it to the jail to pay it for him. So he's asking the court if the court might consider reducing his bond on possibly a PR bond. He did indicate that I believe he lived at the Defendant Center prior to being incarcerated. And so I think that's all he wants to address today, Your Honor, and leave it there.
Any response from the people?
Court's discussion, given
Well, a couple things. Didn't appear, and then how did he come back into custody?
Right, he was picked up, Judge. He did not turn himself in.
He was picked up. He did not turn himself in. I'll reconsider it on the 18th, but at this time, motion for bond reduction denied.
Thank you, Judge.
Court calls case People versus Joshua Reed Freeman.
Your Honor, the practice pursuant to Michigan Court Rule 8.120 under the supervision of Forensic City Attorney Ashley.
Where are you from?
Ireland.
Yes, all right, good. Permission.
Oh, that's auto, then it's automatic.
Yeah, it's, yeah.
David I. Goldstein appearing on behalf of the defendant.
Jay Shuri, Raymond.
Thank you. You're requesting an adjournment?
Yes, Your Honor, we have the written discovery, but I just got the videos yesterday, so we need an opportunity to review them. The date that I'm going to be back from vacation is July 2nd.
That's what I tried. All right. I'll adjourn the matter to July 2nd, 2026, 9 is bond continued. All right. Thank you, ma'am.
Oh, I'm doing it.
The court does call the case, People State of Michigan versus Elijah Hudson.
And then on behalf of you, Your Honor.
Mr. Burkett, can you state your appearance, sir?
Yeah, Raymond Burkett on behalf of Mr. Elijah Hudson. Thank you.
Your name?
Elijah, will you introduce yourself to the court?
He did.
Oh, okay. Yeah.
What are we doing?
Okay, Your Honor, at this point, we filed for ask this court to do a competency to stand trial and a criminal responsibility based on my conversations.
So you're asking forensic evaluation?
Yes. Competency.
I would need I will set it. I'll need the orders in to the court. So forensic evaluation is ordered. I'll set a competency hearing for
September 3rd.
September 3rd, 2026, 9 a.m.
Thank you.
Bond at this time will continue. Thank you. Sean, is this okay? Court does call the case of the people of the state of Michigan versus Svid Kishan.
And then on behalf of you.
Brian stepped out.
All right. While we're waiting for him to come back, can counsel approach, please?
My
to the victim's residence. Your Honor, at this time, the people would be asking for the defendant to be placed on the GPS tether within the open to the victim's residence. The people have learned further information about this bond violation, would like to do some further investigation. So I think at this time, our request will be to add that bond condition of the GPS tether.
All right.
Your Honor, I'm going to make a somewhat mild objection, but first I want to address the fact that my understanding is it's already a bench warrant. So if there is, I'm asking that it be canceled. I don't know if it was ever signed. I know.
Yes, it was signed. Off on, and I think entered, was it not? All right. So what I will do, he's here, so I'm going to cancel the bench warrant.
With regard to the GPS tether, Your Honor, just very briefly, my understanding after reviewing the discovery and having a brief conversation with the complainant, there has been no contact since that time, physical, electronic, in any other way. So I don't know that a GPS tether is really necessary in this situation. And there was no allegation, even in the bond violation, that there was any physical contact. It was the leaving of a voicemail message.
Since I'm adjourning this and accommodating schedules, I will adjourn the probable cause conference to July 2nd, 2026, 9 a.m. With reference to bond, I will cancel the bench warrant. I'll reinstate bond with the previous condition, with his conditions. I will add a BS location correct other with an exclusion zone for the victim's residence.
But no curfew or anything of that nature.
No curfew.
Okay. All right. Thank you, Your Honor.
Thank you. Okay. Court calls case People versus Charles Johnson.
Overall, on behalf of Mr. Johnson. Johnson, please state your name for the record.
Charles Bernard Johnson, second.
Thank you.
And Your Honor, may we approach?
Really?
Just very brief, the judge.
Sure. She doesn't know which way to go.
Oh.
I got Polly back on. All right. Court calls the case, People versus Josiah Miller.
As felt with the people.
David I. Goldstein appearing on behalf of the defendant. I don't see him on the Zoom, Your Honor.
I'm sorry. Okay.
And Your Honor, this was Hillsdale, I believe, County Judge
Yes.
last time as well. So I do know that Mr. Goldstein has spoken to this client and he tends to wait. I don't know if the court will do it without him being here.
I can't.
Yeah.
Your Honor, I'm going to make a suggestion. I made it to Ms. Feltus, and we both agree it's not the best suggestion, but they're not going to honor a Zoom writ. So I'm asking you set this matter on July 2nd and have the prosecutor issue a corporeal writ, have him brought here. Otherwise, I don't think we're ever going to get him.
I don't have an issue trying for a corporeal writ. I would ask if he could not on the week of the 4th of July, because we might have gone plus. I know that there are going to be more staffing issues when we have a major holiday coming up. So if we could do the 9th.
9th.
All right, let me check that date, Your Honor. Yeah, that's fine.
Turn it to July 9th, 2020. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court does call the case People versus Tanya I'm sorry. Is it Naya Lee, I think.
As felt with the people.
Morning, Your Honor. Christina Costantino appearing with and on behalf of Naya Lee. Ms. Lee, can you unmute and state your name for the court?
Naya Lee.
Okay, thank you. All right.
Your Honor, we're asking for an adjournment of the PCC. There is a companion case with this case that is scheduled for June 22nd of this year. So we would ask if the court would consider adjourning this PCC to a date after that date.
Oh, it's set elsewhere on the 20th.
Yes, it's set at the circuit court.
Got it. Probable cause conference will be on June 25th,
That works, Judge. Thank you.
2026. Now, bond continue.
Thank you very much, Judge. Have a good rest of your day.
Is that it for you?
That's it. I'm out of your hair.
Well, no. I just take the rest of these people with you. All right. Thank you. Have a great one. Court calls the case People versus Kyle Pennell.
Good morning, Your Honor. May it please this honorable court, David Burge, Kyle Pennell, who's approaching.
Your name?
Kyle Pennell, Your Honor.
Thank you.
Your Honor, discovery is complete. We're requesting an exam in this matter.
Would people have their witnesses available the 16th?
We'll do our best for them.
Preliminary examination in this matter will be set June 16, 2026, 9 a.m. before Judge Moore.
Judge, could I briefly address the issue of bond?
Certainly.
Thank you, Your Honor. Your Honor, bond's currently set in this matter at $500,000 cash surety. Understanding the serious nature of the charge, Your Honor, I have information that the victim in this case, the alleged victim in this case, not only was potentially the initial aggressor, tried to jump in my client's car. Car was the alleged weapon in this case, Your Honor. His injuries sustained were minimal. I think his toe might have been run over at worst, Your Honor. I have text messages from the complaint. He was at the casino the next night and was released from the hospital hours later. Understand, Your Honor, my client does not have a perfect record, but he's been some time since he's had any issue. He does his fiance, Your Honor, who's pregnant, is present in the court today in support of him. They do both reside. He is employed. I'm asking the court to consider at least a reduction in the current bond, again, set at $500,000 cash surety.
Sloans. Thank you. Does he have other, what's his record like? Because
Give me
I mean, I'm having some pause on this only because at arraignment, there was a substantial bond that sometimes in and of itself can be unusual.
Are you looking through the criminal history?
Well, for some reason, his bond got set at $500,000.
No.
And Mr. Burgess, properly so, is asking for, in essence, a reduction or his release. But I'm not hearing anything from the people that is telling this court that a $500,000 bond is
What I have.
appropriate. And but somehow at arraignment,
I wasn't present, Your Honor, but yeah.
no, and I know, but the people were.
All right.
I'm trying to figure out why was this set at $500,000 if they're going to leave it to my discretion, because
I see that there is a bench warrant for a probation violation where bond was denied.
so, okay.
And the charges are assault, attempted murder, assault with a dangerous weapon. I am seeing several cases within the last few years. Not all of them have gone to adjudication, but they are either assaultive or firearms.
Is he held on the
Probation violation, Your Honor?
right?
Yes.
Your Honor, yeah, he does have a, I think he's held, but if he's able to post bond, he could address that issue with the sentencing court.
Bond is denied in that.
Who's that before?
It was like 14.
So his bond is denied out of 14B.
Probation Judge Washington? I think so. I'm not sure why, Judge. It's a misdemeanor matter.
Has he gone over? Does anybody see a date scheduled for him at 14B? Thank you.
You know she's going to have the answer.
So he's set to be seen June 25th. You have this on the 16th. His bond isn't going to be changed there, but
just facially seems excessive, Your Honor.
It'd stop piling on.
Fair enough.
I'm going to grant a reduction. I do consider this charge as serious, but he's not going to be going anywhere. It seems at this point. I'll modify his bond. I'll modify it to $100,000 cash surety.
Thank you, Your Honor.
All right. Thank you.
Very well. Thanks, Joe. All right.
Court calls case People versus Joshua Hines.
Sherilyn Foster Tucker on behalf of Joshua Hines, who appears on the Zoom.
Mr. Hines, can you state your name?
Joshua Hines, sir.
Thank you.
And Your Honor, we're requesting an adjournment. I just got this case yesterday, so I still need discovery. And if I could briefly address bond.
So,
Your Honor, he does.
Go ahead.
My understanding is that he's currently testing in Washtenaw County at Community Corrections. He lives in Shiawassee and is on
County?
Yes.
Does?
Yes.
Should make her say Shiawassee. No.
And he's on probation out of Shiawassee County. And so he is hoping to get it so that he can test. He's testing in Shiawassee County and has signed a release of information. So he's hoping to be able to continue doing the testing there and not have to drive the hour to community corrections to do his testing here and repeat it.
Understood.
Yes.
I'll adjourn the matter to June 25th, 2026, 9 a.m. I will prepare an order for the court. I will sign off on an order allowing him to test in Shiawassee County.
Okay.
As they release information provided to community corrections here so we can see the results.
Okay. Thank you, Your Honor.
Thank you. Court calls the case People versus Wesley Brand.
People.
Assistant Public Defender Donathy Lebo for Ms. Brand.
Your name, sir? Wesley Brand.
Andrew, and I believed I had a green sheet, but it just went missing. Yeah, and we'd be requesting an adjournment order in order for Mr. Brand to review the video on this matter, which I received yesterday.
You received the video yesterday. He needs to see it.
Yes, Your Honor.
We get all that done by the 18th?
I don't see why not.
All right. Probable cause conference in this matter, June 18, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case People versus Kelly Ott.
People.
Sherilyn Foster Tucker on behalf of Kelly Ott.
Hello, Your Honor.
Hello. State your name for me, please.
My name is Kelly Ott.
Thank you.
And Your Honor, we're requesting an adjournment. Mr. Bernstein is still needs discovery to review it.
That objection, I'll adjourn this matter June 25th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Court
Thank
calls
you,
the case. You're welcome, ma'am. Court calls the case versus Shelby Barber.
Me, Assistant Public Defender, could not be carried out really, Your Honor, on behalf of Ms. Shelby Barber. Mr. Shelby Barber.
When you know, all right.
Judge, I have not made,
You walk slow and talk slow, that doesn't make them appear.
I was hoping something was gonna happen, but today's not the day. Your Honor, I have not been able to make contact with Mr. Barber. I'd be asked for an adjournment.
Bench warrant will issue for defendant failure to appear. Bond will be set in the amount of 10,000 cash surety.
Thank you, Judge.
Court does to the people of the state of Michigan versus Stephen Douglas Wainwright cases.
That's about for the people.
Mr. Wainwright.
Assistant Public Defender Donathy Lebo for Mr. Wainwright.
Mr. Wainwright, can you state your name, please?
Oh, how are you?
I'm great.
Oh,
what's your name?
Well, if you say so. Actually, I'll say Stephon Dallas Wainwright. Let's start with that.
Okay, that's Mr. Wainwright. What are you doing?
Let's go where the defendant was declined competence for forensic psychiatry. Defense counsel at that time intended to seek an independent evaluation.
Correct.
No longer want to do that, simply to the finding of competency.
And Your Honor, that was my intention. However, seeing Mr. Wainwright's indications today, I believe we may need to revisit that. So I'd like to trust an interim to go speak to him again.
Your son cannot ball out. Put that nigga in the sewer.
Hold on, Mr. Wainwright. You want to do what?
I'd like an interim to go speak to him again, Your Honor.
You want to speak to him again?
Yes, please.
All right.
I'll just hire someone comes to it.
Okay, somebody's going to come down. Mr. Wainwright, somebody's going to come down and talk to you again. Make sure everybody's headed in the right direction. So I'm going to adjourn this out to June 18th, 2026, 9 a.m. Thank you.
Thank you, Your Honor.
Court calls the case People versus Kevin Shabari Lowry. Turner Bay Lowry, actually, I think it is.
Your Honor, Amy Lucas requesting permission to practice.
And that. Fine.
Your Honor, Amy Lucas requesting permission to practice pursuant to Michigan Court Rules 8.120 under the supervision of a public defender, Jay Phelps.
Really?
Yes.
You got Bellinger?
I do.
How did you draw that short straw?
I think I got lucky.
Really?
I really do.
That's beautiful. All warm and fuzzy inside now. I don't think I've asked you on the record. Where are you in school?
I go to Wayne State.
Wayne State. Okay. All right. Where'd you go to undergrad?
Kalamazoo College.
All right. Where are you from?
Plymouth, Michigan.
Plymouth.
Yep.
Okay. So you're a Michigander, just haven't left.
Nope.
All right. It's like some of the rest of them. Permission to practice is granted.
Your Honor,
Hold on. Sir, can you state your name, please?
Kevin Williams, Shinabar Lowry Jr.
Thank you, sir. Go ahead.
Your Honor, we're seeking to adjourn the matter out a couple weeks. We just received the police report yesterday, and we haven't had an opportunity to go over it with the client.
Okay. That objection, probable cause conference, June 18, 2026, 9 a.m. bond contingent. Thank you. Thank you, sir. Court calls the case People versus Chance Saylor.
Alexander, on behalf of people, Your Honor.
Michael Gaddy's defender on behalf of Mr. who's making his way to the podium, Judge.
Your name, sir?
Chance Baylor.
Thank you.
Your Honor, we're asking for an exam in this matter.
Discovery is complete.
The best of my knowledge, Judge.
People have their witnesses available to 16th.
Perfect.
Preliminary examination will be set in person. June 16th, 2026, 9 a.m. before me. Okay. Bond will continue. All right, thank you.
Thank you.
Court does call the case. David.
On behalf.
Thank you.
This is Public Defender Zach Binney with and on behalf of Mr. David Proken. Sir, please state your name for the record.
Henry Michael Davis.
Thank you.
Yes, sir.
Your Honor, we're seeking an adjournment to review discovery and then would ask to be heard on bond.
Okay. PCC will be adjourned to June 18th, 2026, 9 a.m. As to bond.
Your Honor, Mr. Davis, him and I spoke for about an hour on Monday. He stated to me that he had been doing well, but then in December, he stopped taking his meds, stopped going to his psychiatrist, stopped following the 12 steps, going to AA meetings, and ultimately relapsed in February. He does have another case out of Oakland County where he has been sentenced to a year in custody. In that case, he does have a release to a locked door inpatient facility in Flint. So we would be asking for a release to treatment in this case as well.
Response.
The next case out of open is a domestic violence case with a different victim that occurred 2 days after this case. If the court was inclined to send him to treatment, I'll be asking for a tether given the seriousness of these charges and the fact that he was currently under sentence for another domestic violence case.
Anything additional?
Your Honor, Mr. Davis has indicated to me that he would accept a tether.
Well, right, but you're asking for his release. I have some concerns about his release. What does he have something in place regarding his medication protocol?
I'm back on medication. I'm back on medication too, Your Honor. I'm back on psych medications. I'm back on my medications and stuff too.
Okay, but how's that? I mean, how's that happening? I mean,
I seen CMH in the jail. I seen CMH in the jail. I got back on medication about 5 to 6 days ago. So I'm back getting more stabilized. Yes, Your Honor.
Okay, so let me ask you this.
Yes, sir.
If you were released, what things do you have in place to make sure that you're going to stay on that course?
I'm going to go back to my recovery therapist. My mom just talked to my mom's in the courtroom back there. She just talked to my recovery therapist yesterday at New Path. I've been seeing them. I'm going back to my psych, Robert Hughes at GHS, which used to be called CMH in Flint. Back to my social worker, David. Back to working the 12 steps. I've been back doing it on my own myself already. After my 6th time, I've been doing the 12 steps in the last 3.5 years. I relapsed for 1.5 months. I'm basically losing my company, losing my home, losing all my, like everything I've worked hard for. And I've seen where I went wrong. And I would just, please give me a chance to get back in the treatment and get my life back together, please.
Okay. Would the people still have any strong objections if he's released with some assurance that he's going to continue on that path? Because it seems.
I'm sure. I think maybe tether would be good, and then in order from the court potentially to have him continue his communications with CMA to follow all recommendations with them and mental health professionals that he is in contact with.
Okay, so here's what I'll order. At this point, just follow me. I'll deny the bond, prepare an order, counsel, indicating that, but that he would have to be on a GPS tether. And I would agree with the people that he would have to follow the orders and recommendations of CMH here in Washtenaw, as well as the ones in, what is it, Genesee County?
Yeah, yep. Yes, sir.
All right. So if all of that's contained, then I'll sign off releasing him on a PR with those conditions.
Yes, sir.
All right.
Sir.
Okay.
Your Honor.
Thank you.
I'll get that order in today, Your Honor.
Thank you. Was Bellinger yelling at you?
No.
No, because I can have Alan take him out.
No.
Okay. All right. Court calls the case. People versus Deontay Jordan.
Good morning, Your Honor.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Jordan, who appears via Zoom.
Mr. Jordan, can you state your name, please?
Deontay Jordan.
Thank you.
Your Honor, I believe the court signed the order appointing me as counsel. We're requesting a brief adjournment. I don't have the discovery.
Matter will be adjourned June 18th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case. People versus Kimberly Douglas. That's the fastest I've ever seen you now. Sorry.
No, release of evidence. Your Honor, we are seeking to set the matter for examination. Recovery has been complete to the best of our knowledge.
All right. People have their witnesses available the 16th. Preliminary examination will be set June 16th, 2026, 9 a.m. before Judge Moore. Thank you. Bond will continue.
Your Honor.
Well, they don't leave. That's fine. You have rituals. Okay. Court does call the case. People versus Malachi Beverly.
Proceedings, Your Honor.
Assistant Public Defender Jay Bellinger on behalf of Mr. Beverly, who should be in appearance via Zoom or in person. No.
There we go.
What's your name?
Can you hear me? Malachi Beverly.
All right, that's him.
Thank you, Your Honor. We are seeking a brief adjournment on this matter. I am working with Ms. Zendo to see if we can come up with a resolution.
Why not? Everybody else has. Fine.
Okay.
Just kidding. Jeez. All right. Record to reflect you had a bench conference in this case. I will adjourn the probable cause hearing in this case to June 25th, 2026, 9 a.m. His bond will continue. However, I will add, understanding there may be no objection, it probably should have been in place in the first place, a testing requirement that the defendant is to report to community corrections for placement on a SoberLink testing device 3 times a day. And I will be signing that order. You understand that, sir?
Yes, sir. Yes, Your Honor.
You need to get over to community corrections within the next 24 hours. Okay.
Okay. Thank you.
All right. Thank you.
Thank you, Your Honor. And
welcome.
Mr. Beverly, just give me a call if you have any questions.
Okay. I can call the same number?
Yep.
Okay.
Why are you changing? Where? Never mind. I'm going to take it. The court does call the case versus Maisha Gaines.
Michael Gaddy, Assistant Public Defender from East Game, Your Honor. State your name, Ms. Gaines.
Maisha Gaines.
Thank you, man. What are we doing?
Your Honor, we're asking I do have a green sheet. My apologies.
You're asking for an adjournment.
Yes, Your Honor. We're seeing if we can't negotiate something globally. If I could be heard on bond.
18, 2026, 9/8. Yes, that's fine.
Yes, Your Honor. Ms. Gaines was placed in custody a couple weeks ago. Ms. Gaines from our office has had a chance to speak with her. I can't. I believe it's clear to her now that following court orders isn't a choice, but it's something that she absolutely has to do. She's prepared to do that. So we'd ask the court. She has stable housing now, and so I think complying with any conditions that the court sets to ensure both the safety of the public and the that she appear in court and comply with any of the court's orders will be much easier for her to accomplish. So we'd ask the court to maybe reinstate her previous bond and allow her to be released.
Any response from the people? Amen. So first of all, Ms. Gaines?
Yes.
Counsel indicates to me that you now understand you have to follow the court's orders.
Absolutely.
What happened the first time? Why didn't you?
Situations with my living and relationship I was in.
So if I were to release you, how do I know you're not going to just fall back into that and end up back here?
I'm not. I have a stable home now with a family member.
That's different from where you were staying.
Absolutely.
Before.
Yes.
And I believe she would be local here in Ann Arbor, Judge, rather than.
You were on testing, right?
Yes. Well, that's fine. I mean,
no, were you on testing before you were released?
No.
Yeah, that's what I was wondering. What were you testing before? Were you testing?
No.
So you didn't have any alcohol monitoring?
I'm not seeing anything in my mind either, but the people at the site would be asking for alcohol testing. Yes.
Trying to figure out, we issued a no bond warrant. I'm not sure. There's another case, that's why. All right. I got it. September.
11th. It's fine.
It was a while back.
Yeah, so
What did that indicate? She's on some. You were going to community corrections previously, though, right?
Well, when I went to court the last time, they were saying that I had to but I never got released.
I have from my lovely coworker that she never gave it to community corrections, so
She didn't. That's why she wasn't. Got it.
think her request to his grandmother.
Okay, that's why I don't see. All right. Okay, so I'll adjourn it to the 18th. Well, I'm going to change that. I'll adjourn it to the 25th. Previous bond is reinstated. I will indicate that there needs to be a scram tether prior to release.
Approach.
Sure. Hold on. I got it. Yeah. Originally set.
Thank you.
2016, 2026, 9 a.m.
Yeah.
All right, thank you. Court calls the case People versus Maurice Boyd.
Dr. People, I got a special defendant down on behalf of the board, we are both approach. Thank you.
Maurice Deshaun Boyd. Thank you, sir.
Because we're asking for an
You
adjournment.
know what? Good, Mr. Boyd was coming up with it. That's NASA has moved that fast up voting.
What's moving fast?
Work.
You had to slow down.
Yeah, okay. All right, what do we do?
Judge, we want to look into some treatment court options for Mr. Boyd.
All right. Probable cause conference and will be adjourned to 25th, 2026, 9 8. All right. Thank you.
Thank you. God bless. Thank you.
Sure. Court does call the cases of the People versus Taiwan Griggs.
Well, to the people.
Michael Gaddy, Assistant Public Defender for Mr. Griggs, Your Honor. He's making his way into the courtroom.
You know,
On the 24 case. The order on competency?
correct.
Okay.
The order on the meeting.
The order on the findings. All right.
Your name? Taiwan Grace.
Thank you, sir.
Yeah, good morning.
All right. What are we doing?
Your Honor, I've submitted a green sheet. We're asking to adjourn this matter a couple of weeks so that we can continue discussions with the people. And Mr. Griggs does have a hold out of Garden City. There is a release to treatment order in these files signed by Your Honor. He's got a hold out of Garden City that he's hoping to clear up on June 15th via Zoom. I did check the Garden City Court's website. There is an arraignment scheduled that day. It's a resisting charge, Your Honor, a felony. I don't know what their bond will be set there. I was going to ask the court, we have spoken to Mr. Griggs' sister who reports he can't stay with her if he is released. I'd ask the court to consider if he is able to clear the warrant in Garden City to consider a personal bond.
I won't consider it this time until we see what happens in Garden City. You're requesting an adjournment. Is the 18th going to be enough time for you?
Yes, Judge.
All right. Now I'll adjourn these matters to June 18th, 2026, 9 a.m. On the 2000, Mr. Gaddy.
Yes, Judge.
You requested of Ms. Gaines, but on the 2024 matter, a corrected order on the competency finding.
Okay.
To the court. And we need that today if we can get it.
Yes, Your Honor. I will see if I can't get that corrected.
All right. Thank you.
24.
Yes. Is it possible to get a bond reduction? All right. Thank you. Thank you, Mr. Grier. Court calls case People versus Nicole Bragg.
Anything else? Morning, Your Honor. Ashley Hannibal for Ms. Bragg. Requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Davi Lebo.
I thought you were Cannon.
Cannon's not here today.
That's why it's been so quiet. Okay. So just between us, who do you like better?
Tough call. I
know it is.
I might have to go with Miss Cannon. Yeah.
What did you say?
Cannon.
Really? You got to learn. The lawyer should have answered whoever is in the room. Cannon's not here. You should have said Lebo. You're not? I'm offended for you.
Well, I don't think so.
Okay. Permission to practice is granted.
All right. Thank you. We have not been able to get in contact with Ms. Bragg, and we would like to adjourn.
You would?
Yes.
Who told you to do that? You spoke?
No. Yeah.
I see why you like it better. He was putting you up here. You're to get set up because I'm not doing that. Right? All right. I would note that there is also your client has a bond violation and has not appeared at community corrections since release. So a bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety. That warrant will issue immediately. Thank you.
All right. Thank you, Your Honor.
Really shucks. And better. That's that. I don't know. I would have picked Lebo. That's on principle, really. Court calls the case of the People versus Seth Cope.
Is that not here? What do you want to say?
For the judge, Court shall feast to first assistant public defender on behalf of Mr. Seth Cope, who should be approaching. When you arrive, Mr. Cope, please type your name for me.
Seth Cope.
Thank you. We are in the process of the work of a global resolution. I believe Mr. Cope has a few other matters pending. We'd be asking for a brief adjournment.
So how much he's got other cases, obviously.
Judge.
How much time are you gonna?
3 weeks, I would think, Judge.
3?
Please.
Will work. All right.
4 font.
He has a case of the 22nd for a BOP that was up yesterday and that bond was denied. And he also faced a vote to be talking with the same victim denied today.
Got it.
I was just
all right. And you're trying to work it up. Why don't I just do July 2nd, 2026, 9 a.m. See if it's all wrapped up.
Thank you.
Okay. Bond will continue.
Since last year. Go change that.
Court calls case People versus Aaron Brandon.
Okay.
And then I'm gonna.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Brandon, making his way up to the podium, Judge.
Aaron Brandon. Thank you.
We are asking for some exam.
No, you're asking for
No,
what?
yes, Your Honor, we're asking.
You want a preliminary examination?
Yes, Judge.
Yes. All right. Discovery is complete.
To the best of my knowledge, Judge, I believe there's one already set. Is it next Tuesday? No, on a different matter, Judge. I'm sorry.
Okay. So he doesn't have another one set.
They're set for on a different cases of data victims. So these are two separate.
So he's got one set on the 9th or the 16th? 9th? Okay. But these are separate cases. All right. Then and so would the people have their witnesses ready in this on the 16th? All right. Preliminary examination will be set in person, 16th, 2026, 9 a.m. before me. Bond with its conditions works. Thank you. Court calls case Peach versus Ryan Miller.
Assistant Public Defender Davi Lebo for Mr. Miller. Miller, please state your name.
Ryan Scott Miller.
All right.
And Your Honor, firstly, with regard to the bond violation, Mr. Miller would admit to the violation for the syringe.
All right. All right. And what are we doing?
Now, so with regard to the probable cause conference, we'd ask to set this matter for preliminary examination. I would like to address this bond.
All right. Admits the violation. How long has he been in?
Your Honor, that I'm not sure if I can check.
9 days.
9 days, Your Honor.
You want this set for prelim?
Yes, please.
All right. Preliminary examination will be June 16th, 2026, 9 a.m. before Judge Moore. As to bond.
And with regard to bond, Mr. Miller indicates to me that he believes the syringe was left in the vehicle by his girlfriend. He does tell me he's completed an assessment for treatment as of 5/27. He wants to do home and outpatient treatment. He does have a job interview.
Hold on a second. What about the meth?
Your Honor, I was only aware of the syringe. Unfortunately, I didn't receive a formal violation report.
Oh, no, he may now be admitting to other things, but
the judge slammed his hand on the bench and said, "I'm done. Get me the order." The entire courtroom froze. What should have been a simple bond review turned into one of the most intense courtroom exchanges of the day. A woman named Nicole Henderson was asking to be released from jail while awaiting trial. Her attorney argued that every extra day behind bars put her job, her health insurance, and her daughter's future at risk. According to the defense, Henderson had already arranged for a private substance abuse evaluation through her employer's treatment program. The only thing missing was a signed court order allowing the evaluation to happen remotely inside the jail. But that's where everything fell apart. The attorney insisted she had already emailed the proposed order days earlier. The court never received it. The prosecutor said everyone wanted Henderson evaluated before any release decision could be made. The judge agreed. Yet the paperwork still wasn't there. As the arguments continued, the judge's patience quickly disappeared. He reminded everyone that he wasn't refusing to release the defendant. He was simply waiting for one document that would allow the evaluation to happen safely. Then he raised his voice. "I'm done arguing about it." The courtroom went completely